Hello, and welcome to the Voice of Aging. I'm your host, Bryn Malone, and I am the founder of a company called Aging Solutions. The purpose of the meetings and these interviews is to really help you cope with things that you might be dealing with an aging parent, or that you might be dealing with and coping with aging yourself. So I today have a very special guest, an elder law attorney who is also inactive CPA at the moment, but she has her CPA. She's part of the Washington and Spokane County Bar Association and many other accolades. This is Julie Olds. She also does continuing education for attorneys, accountants, and certified financial planners. So we're just really blessed to have Julie come and visit with us today and talk to us about some of the situations that we might be going through from the standpoint of wills, trusts, and or in particularly being a fiduciary for someone, being someone's advocate. And so we're really looking forward to having Julie explain a little bit more about what that entails, what the responsibilities are for advocates and fiduciaries, maybe who should be advocates and who shouldn't be advocates, and really the weight of that role for people. So welcome, Julie. Thank you for agreeing to come.
Thank you, Bryn.
Yeah, you're welcome. So tell us a little bit about your practice. Do you work in a big firm, or tell us a little bit about your history here?
Well, my history. I have worked in large firms, and I initially was licensed in New York. I worked in a larger law firm in upstate New York. We lived in Syracuse, and then I went on to Ernst & Young to complete my CPA. So I've done returns, and then we started our family, and I was actually home for 13 years, and I did a lot of volunteer work. I've served with a lot of not-for-profits, which was its own education.
Yeah.
And then went back to work with a firm locally and was there for about 5 years. And that's when I really started to learn estate planning, realizing I wanted to focus on that as opposed to corporate taxation,
Okay.
which had been more what I had done previously. And I had a knack for it because I really basically like people. You know,
Yeah.
if you like people, estate planning, what you're doing is where you want to position yourself. And so I was working 5 years and then needed to take a break. We had 3 teenagers, and my dad developed Alzheimer's. And so I was really not working professionally for about 7 years, caring for him with my mom, which was honestly the biggest life-changing experience I've ever gone through, besides having children. And, you know, it gives you a lot of insight into the why of estate planning, the why you're meeting with people. So when you sit down, you're looking at their situation with a much broader picture, and you're able to anticipate things that maybe they're not thinking about at that time. And so I wanted to start my practice, and so I went back solo. I thought I need flexibility. I can't be tied to the billables of a large firm anymore.
Yeah.
So I started really slowly in 2017, 2018, and it's really taken off. And I am very blessed. I'm exceptionally busy, but I'm also seeing a changing, emerging demographic of need, and which we'll be talking about as I sit down and meet with people and hear their stories.
Okay. Yeah, there's, as I was preparing for this session today, it struck me, it looks simple on the outside, like, oh, I just go get a will or I just go get a power of attorney. But when you really start picking apart those details, it's very complicated. And so I do want to give a disclaimer here. I cannot give legal advice. Julie is an attorney. She's licensed in the state of Washington. And so any information that you hear today, I would encourage you to really seek out attorneys in your state just to make sure you're in compliance with your own state laws. But in general, we're going to talk about a lot of things that are important to everyone when they're doing an estate plan. So before we dive into some of the nitty-gritty, can you give us an idea of what everyone should have in place? What's a estate plan overview, if you will? Like, how would you describe that to people?
So the goal of my practice was to provide an estate plan at a reasonable cost.
Yeah.
And so if you look at my website, which needs an update, but that is really what I'm trying to convey, because the price point in a lot of larger firms is just not within reach of most people.
Yeah.
So I thought I want to be accessible to people. But I also do work with people with pretty large estates because I have a tax background. So people are coming to me, and what I offer, and most attorneys will put this forward, is you're going to get a will. If you're married, there'll be reciprocal wills typically.
Okay.
You're going to have a healthcare power of attorney, which is when you are naming an agent to make your healthcare decisions for you. You'll have a general durable power of attorney, which is a legal name for the financial power of attorney. I do 2 power of attorneys. I don't do just one, because you can want different people for each role.
Okay.
And then I also do what's called a healthcare directive, which is also known as an advanced care directive or a living will. And that's where you're stating your end of life wishes if you're terminally ill or permanently unconscious. And so I go through those documents with people. I'll often add on, if you are under the Washington estate tax exemption amount of $3 million, I recommend a community property agreement. That's a great document, a will substitute. If you're over that exemption amount of $3 million for an individual or $6 million for a couple presently, then I'm doing more tax planning.
Okay.
Only 2% of people in Washington now fall above the exemption amounts.
Okay.
So the vast majority of people are dealing with these other documents. But then you get into their personal situations, and say if they have a child with needs, we're drafting a trust for that child. They may want to provide in a special way for another family member when they pass. We can talk about charitable giving. That will come up if you want to make a bequest in your wills. And how I like to simplify it for people, they're coming in and it's legal jargon. You say power of attorney, you say will. What is that? A power of attorney is for the living, and a will is for the dead. And so when you pass, that's when your will become, I guess,
The driving force
the
of
driving force. And relevant. The will become relevant when you pass.
Yeah.
Until you pass, the will just sits there, and has no effect on your life. It's your power of attorneys. And I do want to say something. I draft revocable living trusts, and there are certain situations where that's recommended. I don't think it's necessary for most people.
Okay.
In Washington, if you have a home and you have your other assets, which typically have a beneficiary designation on them, like an IRA, they're going to move according to the designation. You don't need a revocable living trust. Where I recommend a revocable living trust is, say you have multiple properties, or you really want to exercise control over the passage of the property, or you have out-of-state property. Like I have several clients who maybe have a place in Idaho.
Yeah.
Then you will not need a probate out of state. And people come to me, and that term probate gets used a lot. Like, what is probate? It's like this mystery.
Yeah, it's got red eyes and fangs.
Right.
Most of my clients are like, I want to avoid probate, right?
Right. So I'm happy really to talk about this because I teach on probate a lot. And Washington has one of the best probate systems in the country.
Okay.
So probate is not something to be feared in Washington. And for a typical estate, it's not going to cost more than $4,000 to $6,000.
Okay. That's good to know.
Yeah. And why I bring that up is because some people are being offered, say, these trust packages that are $7,000 to $8,000.
Just to get going.
And you will still have to hire an attorney to handle the administration and closure of that trust when the last trustor or grantor passes.
Yeah.
So it's not, those also require a level of administration and also oversight from an attorney. So they're good vehicles. They're great vehicles. I've got clients who really need them, but it's typically not necessary for most people. And I just say that because I feel as though there's been a myth put forward about our probate system that is not really accurate.
Okay.
And ideally in Washington, we have what's called a non-intervention probate system.
Mm-hmm.
So when you get appointed as the personal representative after a person has died, the personal representative is the person who administers the estate. And the attorney files the paperwork and gets that person appointed. They get this document called a letters testamentary.
Uh-huh.
And then they go around and shift the assets according to the terms of the will.
Okay.
Or if it's on a beneficiary designation, they just distribute it as that designation says, like life insurance. So Washington is set up so if you have a competent personal representative, they should be doing most of the work, not the attorney. And if you happen to engage with an attorney who tells you that they need to do all the work, that's not accurate.
Okay.
And so that comes around to who you would name in a will as a personal representative.
Mm-hmm.
Not every family member is equipped for that role. And so, if you don't have someone, then that's where I start to talk to people about a professional fiduciary,
Mm-hmm.
which is a service that your company offers.
Yes.
And you may want to name a professional fiduciary to administer the estate.
Yeah.
And there may be even a situation amongst adult children where they really simply don't get along and you need a neutral third party.
Yeah.
So, but that's really the probate system. And then, so the assets are in the estate, the PR is appointed, they pay the creditors off. You have to pay all the bills.
Give the notification, pay
Yeah.
the bills.
Pay the bills. And then once all the bills are paid and there's a 4-month statute of limitation for creditor claims, once that closes, then you can start distributing the estate.
Yeah. Which is why it's important to go through probate,
Yes.
right?
Yes.
Because once you open a probate case and you get a personal representative, I think also a lot of people call them the executor or executrix.
Right.
Okay. And then it protects the estate after that 4-month period because as a personal representative, you have to give notice
Right.
through public notice, through a newspaper or some other public notice, correct? And then it would be difficult for a creditor to come back after the court has closed that. Am I understanding that correctly?
Right. They cannot make a claim as
Yeah.
long as you've properly given notice.
Uh-huh.
And you actually have to give actual notice to known creditors like a credit card company. Or a
Mhm.
medical bill, say to a hospital.
Are you saying like a written letter or?
Well, actually, what you give them is there's a document that's filed in court called the notice to creditors. You just mail that to them.
Okay.
And then they have notice that the creditor claim window is open.
Uh-huh.
And if they have a claim, they need to make it.
Make it within that 4-month period.
Right.
Okay.
Yeah. And so I've closed several estates, and then a claim shows up 6-7 months later. It's not owed.
Okay.
Yeah, so that's a big benefit. It also closes the window for will contests.
Oh.
And so you file the will with probate, people have a 4-month window in which to contest the will.
Okay.
And so you're giving notice of the probate, proper notice to all heirs, which includes all biological children
Yeah.
and adopted children. And then if they have an issue with the will, they have to retain an attorney to dispute the will.
And start that process.
Right.
So really, we shouldn't fear probate. We should kind of look forward to it, that it's going to protect the estate, and whether that's from a contest from a
Right.
unhappy family member or creditors, correct?
Right.
Okay. It's interesting because I was doing some research, and Aletha Franklin, Abe Lincoln,
Yes.
Tim Conway,
Mm-hmm.
they all had one thing in common. They didn't have a will done.
Oh dear.
Aletha Franklin, they found her will on a couch, handwritten. You know what I'm saying? So it's not just for people who like ourselves who need to do that, but these famous people, even Prince, his will was contested and is still going on after 6 or 8 years after his passing. So it's kind of crazy, and I think that's the probate process in Washington. Sounds like it's a very good process. It really protects the estate when
Oh,
it's set up
yeah.
right.
Yeah, it's very straightforward.
Yeah.
And I can't say that about other states. I
Yeah.
mean, if you live in California, you have to have another mechanism to move assets besides probate. It's so expensive.
Yeah.
But Washington is not that way with this non-intervention system.
Yeah.
Now, in that, who qualifies? You need a valid will, or if you don't have a valid will, then the courts have to permit it. And courts will, in circumstances, allow it, but the estate also has to be solvent, so assets greater than liabilities,
Hmm.
and then you will be granted a non-intervention probate.
Okay.
And
It's not based upon the amount of assets in the estate.
no,
So, oh, you got $4 million, and we're going to go through this long, drawn out
right.
probate and eat up all those assets is what I think people would be worried about.
Right. We used to have what was called a court-ordered probate or a full intervention probate. And so when you open a probate, every action that was taken with the estate had to be approved by the court. And that's when you were hearing about probate fees being $50,000, $60,000, $70,000.
Wow.
And that's not necessary anymore.
Okay.
Right. Yeah.
Yeah.
So most estates will qualify for this non-intervention system. Now, there are situations, again, revocable living trusts, where there is a reason to do them. And so I don't want to negate that for people.
Yeah.
But I would say most clients, so describe your average client, because I'm sure that's my average client.
Yeah. So that's a great question. My average client, they have they're homeowners.
Right?
They worked all their life. They've rolled up their sleeves. They've gone to work. They've put some money away for their retirement. Some of them have pensions. I deal a lot with veterans, and so they're in that veteran system, and they get veteran pensions and those kind of things. And they have 3 to 4 kids, not 2 kids, but they had more kids back then, so it's a little bit more complicated from the beneficiary standpoint. But most of the estates, liquid assets are, I'm going to say, between $350,000 and $700,000 plus the home, and whatever value that might be. And then on the outliers, I'm going to say I have clients who have multiple properties in multiple states, and they do have the trust. But I am confronted with this question each time, is like, hey, I need a trust. And literally, I had lunch on Tuesday with a gentleman who's 73 years old, and he and his wife are now finally going to get their estate affairs in order. And the first words out of his mouth is, I need a trust. And I looked at him and I said, the gentleman next to you, in my opinion, and again, this is just my opinion, and you need to check with your attorney, he needs a trust. He's a business owner. He has properties in multiple states. And I don't know what his net worth is, but I know it's a lot more than yours and mine combined. Too much laughter at that. But yeah, so that's kind of typical. I agree with you. There's been this push to do trust. And on my way down here for this interview with you, one of my clients, and I'll kind of give you her background. She has a trust. The house is in the trust. She has about $2.5 million. She has investments, no property outside of the state, and she wants out of the trust, and she doesn't know how to, because she had to she sold the house after her husband died, then moved to another house, but that house was in trust, and so this house has to be in trust, and it's becoming really confusing for her, honestly. She went to the bank the other day. We're doing taxes, so I'm getting all of her tax paperwork together for the accountant, and lo and behold, there's a 1099 interest statement with her husband's name on it. She went there, and they couldn't give her any information because she's not on the account, and you know, she had the death certificate, but she was looking for the, what is it, certificate of trust? Is that what you call it? Or the,
Right.
yeah, on the front page of the trust. And she wants out. She wants just something simple so that she can manage her estate easier. And so she actually asked me if I would ask you, how do I get out of this thing?
Well,
I said, I don't know if
I've
we have
helped
enough
people
time
do
for that.
I have helped clients do that. Well, so this is something I want to explain about revocable living trusts.
Yeah.
And they're a good vehicle if they're properly funded.
Uh-huh.
But if you have an asset that is not titled into the name of the trust, let's say you have this rogue investment account that never got titled
Title in
into the
there?
trust,
Yeah.
you will have to open a probate.
Okay. Okay.
And so for those to be proper mechanisms, you have to make sure that every asset's titled into the trust or it moves by beneficiary designation. And so when I initially wasn't working on a lot of revocable living trusts, and then all of a sudden my practice shifted and I started working with a lot of couples who'd moved to Washington and had paid attorneys for these giant
Jet
trust
trust.
packages.
Yeah, I see them all the time.
Right.
Yeah.
And so I would sit down with them and we'd open up these beautiful documents and we'd go through their assets and nothing was in the trust. And so I would say, well, we can go through the process of funding everything into the trust, or we can scrap this estate plan that you've paid for.
Yeah.
And,
Probably thousands of dollars.
right. And we're going to go with a basic estate plan. And so, for instance, for me, if I'm working with a married couple, I'm just going to give you a flat fee
Yeah.
because I know what it is. I just quoted it to 3 people. I'm going to do your reciprocal wills, I'm going to do both your power of attorneys, and I'm going to do your healthcare directives, and I'm going to do a community property agreement. And I have some mechanisms in there. And you don't need tax planning. I say $875.
Okay.
I think a lot of firms are about twice that, a little more,
Yeah.
2.5.
I think a little bit more.
Yeah,
Yeah.
but I've kept my overhead low. So I try to keep a fee structure that's affordable to people so they get it done. That's really been my goal, because if you don't have these documents in place, it's really not good.
Yeah.
Fortunately, I have very low overhead, so I can do this. But that's really it. So they're taking these massive binders and they're useless.
Yeah.
I had, out of 6 couples, it was in 2024, it was my year of out-of-state trusts. Out of 6 couples that I worked with, 1 had the trust properly funded.
Well, it's a lot of work to fund a trust.
Yes.
You have to take deeds. I mean, you have to go to your bank. You have to show them the trust.
Yeah.
It's a lot of running around.
And so, but done correctly, it works.
Yeah.
And so, again, just explaining that as people contemplate what vehicle do you want to move assets on death? Because that's really what you're trying to do, is get an asset to who you want it to go to. So one of the mechanisms for moving a house, and I'm sure you've seen these, and these were, I think it was around maybe 2017, but our legislature did something really good, and they allowed for transfer on death deeds. They are super slick, and I use them a lot. And so I'm going to take a sip of water and explain.
Okay. Yeah.
So I just filed one yesterday. And what a transfer on death deed is, so let's say Mike and I want to pass our primary residence to our home, to our 3 sons in equal shares.
Equal shares.
So the deed would be drafted, and on the death of the first spouse, it goes to the surviving spouse. On that surviving spouse's death, it goes to the 3 named grantees in equal shares. All you have to do is file the death certificate and it moves title. That's it.
Oh, that's slick.
Yeah. And so to draft one of those, and I'll quote another attorney. Because we met and talked about just working, we have a similar client base, and I just met with her last week. I think this is pretty normal. She charges about $500 for the deed, and then where it gets expensive is the county filing fee is $305.
Okay.
So that's what you're looking at. And then when you pass, that home will just move to your named grantees, your heirs.
Okay.
No probate,
No nothing.
no nothing.
What if it's in a trust? What if the home's in a trust?
So what happens if you title the home into the trust, then you actually have to hire an attorney to deed it out of the trust to the named beneficiaries.
Okay.
So you're still, that's what I'm saying in terminating a trust, wrapping up a trust, it's not that different than wrapping up an estate.
Okay.
Because you still have to take the assets in the trust and
Take 'em
move
out of
them
the
out
trust.
to the beneficiaries.
Mhm.
But you don't have to open a probate to do it because everything's titled in the trust.
Mhm.
So that is an advantage. So I'll give you two other arguments for a trust. Privacy, if people don't want their assets known
Through the probate process.
through the probate process. But what's interesting is you don't have to file the inventory and appraisement of an estate with the court. And so, but you do have to file the will. So there is a possibility that someone can go in and read your will, you know, if they can find your case number.
Case number.
Right. But so the will for a revocable living trust is very general. It's called a pour over will, and you actually don't even list the beneficiaries of the estate. It's all set forward in the trust. However, so the trust is not public. The other reason for a trust, and I heard this from another attorney who works a lot with even a more senior population than myself. She said it's easier to manage assets through a trust when someone loses capacity. Because you can name them as a co-trustee and then they go in and they can work the assets and not have to use a power of attorney. But I can say, so let's say you do the what I call the more traditional estate plan and you just have your power of attorneys. There's no issue. You're named as the agent on the power of attorney, and then the individual, the principal who you are advocating for, you just go in and that financial institution will work with you to pay bills or do whatever you need to do based on the power of attorney form. And Washington is under the Uniform Power of Attorney Act, which is, again, a law that's been legislated in most states. It's a very good act. And so the agent on your power of attorney has a tremendous broad powers to manage your estate if you lose capacity. So the question is, why would you want to do that? Why would you go about with a power of attorney? And I know that you used to work as a professional guardian and conservator.
Yes, that's correct.
Right. So let's put forward a scenario. I'm going to use my husband and I.
Okay.
So let's say we never do power of attorneys and Mike has a stroke and becomes incapacitated. So I'm trying to manage things for him. And they're saying, you have no authority, you don't have a power of attorney. You're actually going to have to go get appointed as his guardian and conservator. So to go through that process privately is about $8,000 to $10,000. And
because you have to get an attorney
right
for Mike. He
Right.
needs representation, correct?
an attorney for me,
Attorney for you. And then a guardian ad litem, which is
and now it's a court visitor.
a court visitor. Okay.
Right. And they investigate and determine if I'm qualified to serve. And there's no guarantee that they'll say I'm qualified.
Right.
And so people are shocked when they find themselves in that scenario because they never got their power of attorneys done for that person. And so I had this nice young man call me, and his mother had been losing her capacity and she could no longer sign her name. And they were desperate to get a power of attorney in place for her. And I said, if she cannot respond to me and tell me what she's doing and, you know, identify what's in the document, she doesn't have the mental capacity to sign it. And she also has to be able to sign physically. So we talk a lot about wills as part of an estate plan, but I would say power of attorneys are just as important because things happen in life. And once capacity is gone, it's gone. And you see that, I know, in your clients.
Yeah, and I think let's just really drive this point home because it's so important. We've been talking about really how to transfer assets at death.
Mm-hmm.
But what I deal with in my business practice and why I established the business was really to support people in life,
In life.
in what they're, and it's messy, right?
Yes.
And it's complicated. And you alluded to it at the beginning when you were telling us about your story about your family's history with Alzheimer's, and you took, time off to look after your father. 7 years, you put your life on hold for 7 years, basically. Were you raising kids at the same
Yes,
time?
we had teenagers,
Yeah.
which
Okay.
have their own form of dementia.
Yeah. Selective
So,
hearing.
yeah, yeah.
Yeah.
Anyway, but
Yeah.
yeah,
So
actually, it was actually that whole process for a whole family. It was a seasoning process for all of us, for
a
the boys.
seasoning process. Yeah.
Yeah. You watch your grandfather, who you've known, who's this robust, amazing person,
Yeah.
and then all of a sudden gone.
Yeah.
They're physically but gone.
Yeah.
But yeah, no, it is the reality of what we're in.
Uh-huh.
And you know, I mean, you deal with this in your practice, but there's somewhere between 200 and 400 different types of dementia.
Oh, I didn't know it was that much, but yeah.
Yeah, and
Yeah.
so it's if we live long enough, we'll get it.
Yeah. So we're all hoping for it at
Yeah,
some
we're
point.
all hoping for that.
Yeah.
Yeah, so I mean, that's just the reality.
It's interesting why people, the same gal that asked me to ask you about the trust, she also said, because she's had a medical scare recently, and her doctor scared her really into action to get all of her things that she's been thinking about, and she's got some nieces and nephews, and she was not considering, she was going to live forever, although she's got these chronic illnesses and some complications, and her most recent medical issues have really put a sense of urgency into getting things done. And she expressed to me, she goes, I didn't want to think about these things because they're hard to think about, because then you're facing in essence your mortality. And she was really struggling with that. But then, she's mad at the doctor, but the doctor was just kind of being honest with her, which I really appreciate, right? And because it allowed her to kind of kick it into gear,
Right.
and get things done. And I'm sure you see that in your practice. I see it all the time. People kind of delay, and then it becomes an emergency situation. And I always tell them, if we do this in piecemeal, you actually pay me less versus having me come in and manage an emergency situation or crisis for you, right?
Well, and the other piece I would encourage, and I've been blessed to work with a lot of clients. I mean, I was actually counting in the last 21 months, I've had 240 clients. And so I've been
Wow.
working a lot,
Yeah.
but it's given me an opportunity to meet a lot of people and see a lot of scenarios. And I learn something from every client I have,
Yeah.
just like you do.
Yeah, every client's so valuable.
So there is, I don't do this in my practice, but it's actually something I could see someone taking on, because attorneys, tend to be more expensive for this role, but I believe in a family meeting. I believe that if the people who are drafting the documents, naming the agents on their power of attorney, setting up their wills or their trust, whatever vehicle they choose, if they can sit down with their family and explain things.
Yeah.
And when you have dialogue, you are much less likely to have conflict.
Yeah.
And then when the crisis situation hits, people are ready to respond.
Yeah.
And even the healthcare directive, which is your end of life wishes, even being able to talk about that, at least with the people you've named in your documents, and say, I've put you as the agent on my healthcare power of attorney, which means that you could be in the situation of having to choose whether or not it's time to cease life support. Yeah.
And that is a weighty decision. That's
Right.
something you have to live with. And it kind of goes to, I want to dive into this a little deeper, being a professional fiduciary or power of attorney, assuming that role.
Right.
I'm with you on the family meetings. I encourage family meetings. I hold family meetings to kind of set the parameters for what things look like. People, when I talk or going to bring on board a new client, I say I have to get to know you. You have to get to know me because I need to know what's valuable to you,
Right.
what's important to you, because that's what I'm going to advocate for. I'm not going to advocate for things the way I feel. I'm going to advocate for things the way you want them. And
Right.
so we do a lot of goal setting. And then we meet with the families because I find that I have less resistance in implementing, because I work for a lot of kids that just, they're busy, or for parents too, that it's overwhelming to be a power of attorney or attorney in fact for folks. So talk to us a little bit about what that looks like, the difference between the healthcare side of it, the financial piece of it, who you would recommend to one of your clients to be, how they choose that. Do you coach them up on, well, what's your family dynamic? I mean, what's that process look like for someone like yourself?
Actually, yeah. Well, what's interesting is I draft these documents, but I'm not necessarily there for when they're being utilized.
Yeah.
So what you're talking about are attributes and people. I mean, the slam dunk is if you're blessed with a son or daughter who's like a financial guru, they're going to be great on your financial power of attorney,
Yeah.
and they're trustworthy.
Mm-hmm.
So, you may have a family member or a brother or sister. You may have a sibling that you trust that if you lost your capacity to manage your finances, would they pay your taxes? Would they make sure the property taxes were paid? Would they handle those basic financial responsibilities? And then also within that power of attorney, let's say you're a business owner. Do you have a plan if something happens? Who would step in to help run your
To that
business
role, yeah.
into that role? And so when I meet with business owners, I often tell them, hey, I'm doing this power of attorney, but write up a set of directions. Something
Yeah.
happens to you, what needs to happen? Who would they retain? What would they do? So that gets more involved.
Yeah.
Healthcare, that can be a different personality. The person who's very comfortable with financial decisions may not be the person you want standing next to your hospital bed communicating with the nurses and doctors
Mhm.
about your healthcare records, what medications you're on, and what decisions you need to make. And I have an advantage in this area because I'm married to a physician. And so we, for a long time, actually, we've
Yeah.
been married, but he comes in from his clinic day and he tells me all, he doesn't give names because we're under HIPAA, but he describes these scenarios that people and family are getting into. And, they have the family member coming to the appointment because they need that advocate. So
Yeah.
you're thinking of the person that you would want as your advocate. Now, between spouses, it will be typically your spouse. However, I get into scenarios, and this gets a little touchy, but what if that spouse is already showing dementia?
Mm-hmm.
So it may not be appropriate to name them. You may be thinking, and that gets delicate. Okay, you have this diagnosis. I think it's time to name the adult child to be the agent,
Yeah.
and act on my behalf. Now, what if you don't have family members or good friends? What
Yeah.
do you do, Bryn?
You hire a professional advocate is what you do, and an advisor. That's exactly what you do. And that's why we started the company, was because we saw this explosion of professional guardians coming through. And I'm like, hey, we're putting the ambulance at the bottom of the cliff, not the top of the cliff.
Right.
Let's work with people and help them goal set and educate them along the way as to what it's like to age. And don't be afraid of going to the attorney and getting your will drawn up, and it doesn't mean you're going to die tomorrow. You know what I'm saying? And people are, they're so reluctant. And I'm a huge coach and encourager for people to go and get their stuff taken care of. And I have literally an 89-year-old client right now. Her beneficiary is her 94-year-old cousin. Okay. She does not have a power of attorney, but she's going to appoint me as her power of attorney because she's thought that I would probably last longer than what she's going to walk on this earth, for. And she's just now kind of getting into the mode at 89 years old of getting all this done and redoing her will. And so we're looking at, charities that she can leave her monies to, because she's never married, no children. And her cousin was married, but no kids on that side. So there's some distant cousins way out there. So now at 89, she's embracing this. What am I going to do? Where's my assets going to go? And kind of taking control of that. But I see this all the time with power of attorneys as well. In a situation right now where an ex-wife is the trustee, co-trustee on a trust. The gentleman is 94 and he's got dementia, but he might outlive her. So then, what are his options? Because he can't appoint a power of attorney, so his option is to go through the guardianship process, right? And the successor power of attorney. So this is what we see with people as they kind of getting older and aging. Sometimes they choose an inappropriate person. That person's either their same age or a little bit older. It might be a friend, neighbor, or church person, as you said. Or they might choose a power of attorney they've never had a meeting with. And the power of attorney is like, what? I'm the power of attorney. I don't want to be the power of attorney. I live in Kansas, for goodness sakes. Right? And we run into that as well. An interesting thing about starting Aging Solutions, prior to COVID and just how it's evolved, is we do a lot of power of attorney coaching. Like, they're confused and befuddled and pulling their hair out. And what do we do? And how do we do this? And I tell them, it's going to be okay. It's going to work out. And you just take a deep breath. But we need to get some things. We need to do some planning and get some things written down. And whether it's financial or whatever, if we can do the goal setting thing first, it's just so important. What's important to that person that you're advocating for? Get that down, whether it's financial or how they want to live out the rest of their days. It's important to have the talk about death and dying so they can execute a living will, or emergency medical pulse form, which we have in the state of Washington here. So we see all kinds of things, and then family dynamics, and I like to talk about the seagull sibling that flies in and right. Well,
oh yeah.
Oh yeah.
They show up for the money.
Well, you took the
I'm
words right out of my mouth, Julie.
I'm sorry. And so one of the topics we were going to talk about, and I see this too, is the adult. There's often one adult child who does the majority of the work. And I just spoke to one 2 days ago about her 94-year-old mother. And I can tell that she's shouldering this and she's doing it. She has 3 siblings, but I don't think they're grasping quite what she's doing.
All the energy, emotional, physical, how taxing it is.
Right. And that, that's also, I'm glad you're talking with people, because you're stepping in. When you're power of attorney, you're also in a caregiver advocate. You're going to be setting up the care. If that person needs in-home care, you will set that up if you're the healthcare power of attorney. And you mentioned something, and so we'll go back. You're listening to me. I've rambled through all these terms. So your basic estate plan, again, you've got a healthcare directive, you've got a healthcare power of attorney, you've got a financial power of attorney, which is also called general durable power of attorney, and you have a will. It's worth noting that with power of attorneys, you can make them effective immediately, or you can make them springing, which is upon a finding of incapacity.
Who finds that? Who does that finding?
A physician.
Okay.
And my concern about a springing power of attorney, and I recommend against them, but I have clients who want them, is if you have someone sliding into dementia and you have a springing power of attorney, unfortunately, and I'm hearing this from my physician spouse, it is
Hmm.
very hard to find a neurologist to render a diagnosis of end-stage dementia and that person has lost capacity until you have what I would call the emergency situation.
Hmm.
And that person is possibly hospitalized, and then you're getting the diagnosis. So you can have a window of gray. And so if you trust the agent on your power of attorney, I recommend making it effective immediately. If you have concerns about an abuse of a power of attorney, which I know you have seen in your work.
Yeah.
So I worked as a court visitor for 6 years for the county of Spokane, and I would evaluate vulnerable adults and if
Hmm.
they needed the appointment of a guardian and conservator. I was really only taking county cases, so they were pretty straightforward. You know,
Yeah.
I'm going in, there's someone in the hospital, they have no family members, they need the professional guardian conservator. Um, but what was interesting in those situations is I did see a lot of elder abuse. And when you have elder abuse, it can happen through the power of attorney. So there was a situation where it was the granddaughter on the power of attorney.
Hmm.
She was getting into the bank accounts, and this poor person was in a memory unit in a nursing home. And yet you look at her bank account, and she had been at Northern Quest Casino every day for 2 months. And so again, that's elder abuse, that's
Yeah.
fraud, blah, blah,
Yeah.
blah.
Taking money.
Adult Protective Services is involved. The power of attorney was revoked, and now we're going to get a professional guardian conservator.
Yeah.
So the agent that you pick on your power of attorney, you are giving that person a lot of authority. And I mean, you're familiar with this. Sadly, most elder abuse happens within families.
Yes.
It is by another family
It is
member.
by another family member. I think it's over 80%.
Right.
Yeah.
Yeah. So, you know, I talk about that with clients. I think most people have an intuitive awareness of this, but I don't work in this area because it typically involves litigation.
Hmm.
But, you know, people, you know, the scenario, the eldest brother with the drug problem has moved home and moved in with mom
Uh-huh.
and
That is so common, right?
taking over the finances.
Mhm.
And then bars people from seeing mom.
Starts the isolation process.
Right.
Yep.
And that is the scenario set up for elder abuse.
Yeah.
And I have people call me because I do give a free consultation. I want to help people and really walk them through the steps of what you do there. But I heard a talk by Adult Protective Services, and this was during COVID, and they said they were getting 60,000 calls a year in Washington.
For financial exploitation.
Elder abuse,
Okay. Yeah.
of some kind. And so again, you don't want to have to discuss that with clients, but it is a reality that when you're naming a fiduciary for yourself on that power of attorney, that person is trustworthy and has integrity and will act in your best interests. And an agent in a power of attorney is a fiduciary.
Yeah.
So they're held to the highest standards of behavior and accountability.
Right. And that's where the hammer can come down on somebody that's in that role. I mean,
Right.
and I think fiduciaries don't really understand that when they're the power of attorney. Some people think, well, they appointed me, I must be mom or dad's favorite. They need to understand it's a very serious appointment.
Right.
And being a fiduciary is not like being a son or daughter anymore. You are that person's advocate, and there can be, civil penalties. There can be a number of penalties if you do not carry out your duties appropriately, right?
Right.
Okay. So I think people need to understand that if they're going to take that role on, and mom and dad need to have that conversation with somebody. The springing versus the immediate. I mean, there's pros and cons to both of those. One, if you're the immediate, a lot of the clients are like, well, I don't need you like right now. So, that kind of frightens them a little bit, like, you're going to take my money from me. But on the springing, the scenario that you brought up, I just referred someone to litigation because his sister moved in with dad, and was going to the casino. This is so common.
It is unfortunately so common.
Yeah, and she was taking him to the bank and withdrawing thousands of dollars. And dad and son were best friends. They hunted, they fished, they traveled, they went to
And
ball
dad is
games together.
declining.
And dad is declining. So that's the trick I want to ask you about, because son was trying to intervene, and dad all of a sudden got very protective of the daughter, the sister that moved in. And, the hands were tied. And I said, you have to go get an attorney. It's going to cost you some money, but it's better to litigate this now, in my opinion.
Yes.
Get it done now while dad's still alive versus after the fact, so other people than the family can gauge where dad is on the dementia train, right? So
I very intentionally don't practice in that area.
yeah,
I know some excellent attorneys who
That do
take
that.
on
yeah,
that type of litigation. Yeah, and unfortunately, the scenario you're describing, you're also describing a situation where that relationship with that sibling is over. That family will now fracture, and when dad passes, they will never recover because trust is completely broken.
yeah,
And so, yeah, I mean, it's a messy process. You get adult protective services involved. The sheriff will show up often. And then, you're getting an attorney to freeze assets so the abusive individual cannot access the
Access anymore.
assets.
yeah,
And it's expensive and it is difficult and draining. And when you talk to people who are going through it, you can't really describe a worse nightmare because there's a betrayal factor by another family member.
yeah.
Like, how can you do this to mom or dad?
Yeah,
And what's interesting is when I've spoken to people who've stolen from an elderly person, the typical response I get is, well, they wanted me to have it. It's like, really?
yeah,
Okay. Well, I'm glad you like your new pickup truck
yeah,
that you went and purchased with their bank account. And so there's an interesting rationalization that goes on in people's minds. And so if that power of attorney had been immediate, son could step in right now and deal with that situation and you can still go to the bank and alert the bank, and the bank can put a watch out
on there.
And some banks will shut the accounts down if they notice a pattern, but they have limited options. And honestly, this would be a whole nother discussion for
a different day.
Well, I mean, to talk about with our audience and what this looks like, and because it is, I think, something that people need to be informed on.
Yeah.
And
it's so important because they think the bank's going to step in and be the sheriff, you know what I'm saying? Or that an attorney or something's going to resolve the situation for them, but that's not the case. It's a long, expensive process with multiple interventions, layer upon layer of interventions in order to get these people. And it is a slow rationalization oftentimes, like, well, I'm the one that's living here. I'm taking care of mom or dad.
Right.
And, you know, I'm doing all the work, and you just come and have fun and take them out once in a while. But I live here. And so I see that rationalization as well. And this is just their way of paying me. And I always tell clients, well, let's get a contract.
Yes.
Right?
Yes.
That you're going to make so much and you get a vacation or whatever. So we're not just taking what you feel is deserved or what your parent, who's probably not cognitively aware of really the value of what they're giving you, that they're just not giving you large sums of money or
well, and what's interesting about vulnerable adult abuse is there are people who have mandatory reporting. It's like with child abuse.
Yeah.
And it's got its own statute, and I don't have it memorized. But I am not a mandatory reporter. It's interesting as an attorney. Now, licensed mental health counselor is. So I think this is such a big topic and you're navigating it, but unfortunately, it is not going to decrease because we have a growing vulnerable adult population. And if I looked at the statute, but there's an age where it's presumptive. Once you reach a certain age, you're presumed to be a vulnerable adult.
Okay.
And then prior to that age, you have to have an underlying diagnosis.
Okay.
So my father, who was diagnosed at 71 with Alzheimer's, became a vulnerable adult
On that diagnosis.
on that diagnosis. And so again, when you're working with an adult parent and you're the agent on the power of attorney, you likely have an adult parent who under the statute is a vulnerable adult. And it's to me, it's really interesting. And my mom was in a situation, and I'll tell you this.
Yeah.
We unfortunately had to get into a little litigation over some property issues. And my mom had to be deposed, and she technically falls into this definition for reasons that I won't go into, but she's still a really smart lady. But the attorney who deposed her actually was very aggressive with her. And technically, what he did through this deposition, I said, this is elder abuse. You can't do this.
Intimidation.
Intimidation.
Yeah. He
accused her of taking drugs. He accused her of being drunk. He tried to mislead her. He threatened her. And I thought, wow, my profession doesn't understand this.
Yeah.
And so again, talking about vulnerable adults, how we will all at some point, if we live long enough, get there.
Yeah.
And that's what I think when I work with these people. You know, you're working with vulnerable adults right now, what you're describing, and they need advocates. And we are not educated on this population and what that will look like. And it's to me, you know, I think that's why both of us are called into what we do, because ultimately you really care and you see the vulnerability in this person that at some point in their life, they may have been running a company.
Yeah. Oh, yeah.
Yeah. Yeah. And
very bright, you know, maybe started something from scratch, that, you know, maybe invented something. I've had clients who were nominated for the Pulitzer Prize, but they became a vulnerable adult, and I was appointed their guardian, you know, and it's just amazing. That's why one of the reasons I love this job, working with people, advocating for them. You meet so many beautiful people out there that just were very successful, but now they're in a time in their life.
Oh, yeah.
They need someone to really stand up for them.
Yeah. Yeah. So I mean, and that's where, getting back to this whole agent person who you're picking, this fiduciary, they are going to be your advocate. And if you don't have a family member or a trusted friend, or even your church, I've worked with people who the church will provide someone, like, we have someone who will do this for you. And they're trained and they offer that, which I think is wonderful.
Yeah, that's great.
You have people like Bryn, who started this company, which is super needed, because you want an honest, competent advocate.
Yeah. Yeah.
And so that's, I guess, that topic, but it is a growing need.
It's a growing need. And, you know, when I started the company, I've actually started a couple different times, because when I was a guardian, again, it's the ambulance thing. Like, I want to put the ambulance at the top of the cliff, not at the bottom of the cliff. How can I educate people about what aging really looks like? It's not, you know, how many times have you heard the golden years aren't so golden? Whoever said that was crazy. And Betty Davis is attributed to saying, you know, growing old's not for sissies, you know, those kind of things. And we're all living longer, you know, that's beautiful on one hand, but most of us haven't encountered this aging thing, and the fact that dementia is pretty widespread, and you know, cancers, and just the medical industry, with, as you said, with the seniors, and we were talking about doctors before we started this interview, and I said something about gerontologists, and you kind of said, well, they all are now, because there's 10,000 people a day turning 65 years old who are needing these services, and industry just hasn't caught up to it yet. So we're glad to be here. And then for my power of attorney, I'll just share this with you and the audience, is for my healthcare, I have a much younger brother. My parents decided they weren't done having kids yet. I thought, I'm number 7, so we can stop. But they went with number 8, and he's quite a bit younger than the rest of us. But he's in the healthcare field. And so he is my healthcare power of attorney. And it's not because and I have 2 children, but I don't want to put that burden on my kids. And he's accepted that burden. I don't want my kids they're in their late 30s, and they would have to understand all the medical jargon and terminology, and they would probably really hesitate about, honoring my end of life care if they weren't quite ready for me to go yet. My little brother, I picked on him enough, he'd like pull the plug right now. You know what I'm saying? So that's appropriate for me. Yeah. And then my son-in-law doesn't know this, but if he's watching, but he'll be the executor of my estate. Again, remove my kids. So I'm more of the model of having somebody that's not so emotionally invested into what I'm doing, and that's where a professional advocate comes from for me. But also just being really careful. I want to protect my kids from having to make a decision that they're going to have to live with about, and we alluded to it earlier, when it's time that mom and dad, they want to transition to a better world than being here, and we're not quite ready. We're not quite ready
Well,
for that.
and so this will leapfrog into another topic for agents on a power of attorney and your personal representative.
Yeah.
So I know you do this with your clients. I advocate this with my clients. I have a form I provide them. I mention you, other services, but you really want a financial roadmap. So what is an estate plan? And that's a really broad term. So I would putting together a comprehensive financial statement that lists all your assets, where they're located, ideally, if you're someone that buys precious metals, where are they? I've had probates with mining rights. Do you have an exotic asset like mining rights in Colorado?
Or mineral rights.
Or mineral rights. Yeah. You want people to know about that. And so anything like that is listed, because if you lose capacity during life and the agent on your financial power of attorney has to step in, they're going to be managing those assets.
Right.
And when you die, they're going to be stepping in, and I joke, it's sort of a treasure hunt. How do you locate things?
But it's no fun.
It's
treasure
no
hunt.
fun.
It's a no fun treasure hunt.
Right. And so you put together a list and you have your assets. And it's interesting. A lot of people are hesitant to do that with the adult child they've named, for example. Like, do we want them to know? I don't think we're comfortable. I just say then take it and put it with your original wills in the hopefully a safe where you're storing your wills, or a safe deposit box, and then update it. And if you don't have it there, let's say it's on your computer, put in a memo, go to my computer under this file, and this is where you're going to find the list.
Yeah.
And then the other thing that I talk about in estate planning, which has become a huge area, is digital assets. And so when I sit down with clients, I say, do you have a digital asset list? And I explain what that is. And it's a really broad term, but it gets into passwords. So passwords on phones, passwords on email accounts. Do you have social media? Would somebody be able to get into your social media account and either shut it down or say, turn it into a memorial page, which I guess you could do with Facebook.
You can do that, yeah.
Yeah. So it's making that information available to someone. And this was not my probate. I heard this from a friend of ours whose wife passed, but I just thought this was an interesting story. Very savvy guy financially, but they took out a credit card when they were first married, and he was in school, so they got it under her name. and it became their airline card. Well, she unfortunately had a congenital heart issue and passed.
Passed. Okay.
And so there's this credit card with all these airline miles on it under her name. So she passed. The airline contacted him and said, "We're going to cash you out of your miles that you would get." And he said the sum was nominal. It's not anywhere near what the miles represented. He said, "I wanted those miles." And so those are the things as you look at your assets that people don't always think about.
Yeah. They don't think about, I tell people I can probably help them find money because we go through this as we're documenting the
Right.
estates. It's part of our best practices, if you will. Like
Right.
if you're going to know people, you have to know people, which takes a high level of comfort with,
Yeah.
but it builds that bond too when you start working with people and they understand that you're really there for them. For me, it was born many years ago. About 35 years ago, I had a couple. Prior to advocating for people, I was in the financial services industry,
Mm-hmm.
and I had a couple. I tell this story often because it's the reason, one of the main reasons I'm here. And they called me up and they said, "Hey, we want to have you come up and document our estate. You work with us on our investments, and we have two daughters, but they don't live here." And they had very nice river frontage property, 40 acres on the river. They had multiple bank accounts. They had multiple investment companies that they were working with. They had insurance products that, which are easily lost. They come out of the woodwork because you get a contract like a life insurance or annuity, and you get that contract. It's not necessarily being housed somewhere like one of the investment firms. They send you the contract, right? And so you put that in your safe deposit box or in your safe, but you have to find those. But that's how I got started documenting and creating that system for all my clients, so we know and we can update that when things change. It's just so important. And I had two clients back in the day, and I would ask them, "How much do you think your net worth is?" And I had two. It was interesting. Two ladies that came on board about the same time, and they both said $300,000. And by the time I got done with one, it was almost $3 million. And one of the local bank's trust department, we referred her there, and so they were managing her assets. And the other one was almost $1 million.
Right.
Right. So I mean, there were stock certificates. There's things that back in the day, people wanted to hold their stock certificates. Now they don't do that anymore. Thank goodness for the past 20 years, more years. But there's still people around. I had a client just 3 years ago. He was an engineer, and I was working on behalf of his son and daughter-in-law. And I said, something tells me he had investments at one point. And his son, who lived 300 miles away, said, "Well, I think so. I mean, he used to kind of do those, but we don't find any investment account." And I said, "Well, we need to start checking the house because that means he has the stock certificates." And they found about $300,000 in stock certificates in the closet.
Yes.
Yeah. So
Yes.
not unheard of, right?
Not
So
unheard of.
just so important to document that.
Well, and so it will be interesting. The people who are interested in this process are either the adult children are seeing the need
Yeah.
for a parent, so they can initiate what we're talking about with the parent, or it's personal to them. And this is what I need to do for my family, those who are close to me once I pass. And yes, what we're talking about, honestly, the financial roadmap or whatever you would like to term this is, to me, as important as the will.
Okay. Yeah.
Yeah. And
why is that?
because when you lose someone close to you, you're grieving. And so I think of how it will be, when like our sons lose the last of either Mike or myself, they will be grieving. And what kind of burden do you want on them? Do you want it easy?
Mm-hmm.
Do you want them to be able to find things easily? Or are or is it going to be a difficult process? And the people who've come to me for estate plans, it's interesting. It's always fun to sit down and listen to a client who said, my parents did it so well. It was so organized. It was laid out so clearly.
Yeah.
I want to do this for our children.
Yep. Well, and I tell people it's the greatest gift you can leave to your kids. Is it a lot of work? Yes, it's a lot of work. You have to go through old records. You have to, it's kind of like going through tax season when you were working and you're looking for all the exemptions, and all that kind of stuff and all the receipts. It's kind of like that. It takes hours. But you know what? Those hours, you're either stealing those hours from your child's life, which is no one's real intention, or you're putting that time in now when you have more time on your hands and you're still able and capable. So a lot of times we go and visit with people and they want us to go through and go through their paperwork, and we document it as we go on our program and computer system. We have a roadmap called the Trinity Plan, and it documents the financial piece. It also documents the healthcare piece, and it also documents the end of life wishes. And we go all the way through even to funeral planning. So we really want to help parents alleviate the stressors and the burden of putting some of these decisions on their kids, because they are grieving, particularly when you lose parent number two.
Right.
I like to kind of use baseball as an analogy for this. When you're the batter and you're up and you hit the ball and you're running around the bases, first, second, third. Well, when mom and dad are gone, it's like home plate being gone. You're stuck at third base. You can't come home. The home gets sold. The heirlooms get liquidated. The family, hopefully, they like each other, and it's a good distribution of and transfer of the assets and the personal property. But it's a lonely feeling being a surviving child when mom and dad are gone. You don't have those birthdays. You're not going over to mom and dad's for turkey dinner at Christmas or anything like that. So I say home plate's gone, and it leaves an empty feeling. So you are grieving, and everybody grieves differently. The other thing I noticed about grief that really impacts how people get along, and if this isn't done, it can create conflict. We bring our childhood experiences with mom and dad to bear.
Yes.
Or with siblings. Would you agree with that?
Oh, yeah.
Yeah. And we all had different experiences. Some were more take on the victim role better than others, or, the dominant role, and, all those things, or I was the special child, or, those kind of things come to play. It's amazing to me. I can always tell what the role was of the children when mom and dad pass, and how they interact with the siblings, and how, they move things. Because I do act as personal representative for estates, so I get to see some of that. And I get to see it while we're doing power of attorney work, and I have siblings who are in my ear about how they think things should be managed for mom and dad, but that's why mom and dad appointed me. Right? So
Yeah. No, those, and if there are unhealthy dynamics in a family, they will emerge in probate, or even through a trust administration, which is why you want your documents done.
Yeah.
And this brings up just a question people have. Well, what if I don't do a will? What if I don't do anything? Well, the assets that you have a designation on are like a joint account with right of survivorship. Those move. But the assets that don't move that way, they're called probate assets, go by what's called the laws of intestacy. And so this is Washington.
Okay.
If you're married, and I have this statute memorized, if you're married and you have no will, your spouse and will take all community property, even if it's a second or third marriage, so whatever that is, and 1/2 of separate property, and then 1/2 goes to your biological or adopted children. So if someone has remarried, any will that they did prior to marriage is null and void now. that spouse can take under the pretermitted spouse doctrine and take what they would get under the laws of intestacy, which would be half of all property brought into the marriage.
Okay.
It will not go as the will's written unless you update the will.
Will. Okay.
So when I also work with couples who have second marriages, so I do recommend getting a prenuptial done if you can do it, and you have significant assets. It's important. I recommend allowing 9 months for a prenuptial agreement to really move it back and forth and get it completed. They're not inexpensive, but they're worthwhile down the road because they'll cover the estate if there's a dissolution, also on death. If you don't have a prenuptial agreement, and I've got a second marriage, or sometimes a third, and parties have separate property, community property, I do a property status agreement that it goes with the will. And in Washington, when you're married, you have community property.
Yeah.
So you control one half your community property and all your separate. So it's important to know what is separate. Inheritance in Washington is separate. So if you're inheriting property, I even recommend noting it in your will in the declaration, like this is my separate property and this is passing under my will. And you may even want it to move via trust. So that's Washington's community and separate property. I could go on about it I could talk a lot more.
Yeah.
So under the laws of intestacy, if you're married and you don't have a will, then you have adult children, they'll get one half. And then if there are no adult children and you're married, they get everything, all separate, all community.
Okay.
And then if you were unmarried, it actually goes up to the parents. And then if the parents are deceased, if you don't have children, I should say, if you have no children, it will go up to your parents. And then if your parents are deceased, it goes to siblings and then out from there. If you die without a will and you have children, those children have the first rights to the property.
Okay.
But again, and that can be somewhat clear-cut depending on the estate and if the children are getting along, because one of them is going to have to step up and agree to be the administrator of the estate, and you're not guaranteed that the court will give you a non-intervention probate. It's really within the court's discretion to do that. If the facts are clear, it seems straightforward. Courts want to do that for an estate, but if not, they won't grant it. So that's another reason to get a will done. And again, I emphasize, if you have remarried, you really need to update your document.
Well, I always tell people that they need to review their power of attorney every 2 or 3 years.
Mm-hmm.
They need to review their will at least every 5 years because people pass.
Mm-hmm.
That might have been named as a beneficiary, might have been named as personal representative. There's just so many changes that consistently happen.
Right.
And I'm like, but it's from my end, honestly, people aren't very loyal to their attorneys because the neighbor says, well, I just had my will drawn up there. You should go get yours reviewed. And I try to tell my clients, your attorney is your advocate. They know you because they did your paperwork the first time. It's easier if you go back to those folks, because you have a starting point, right? They have a starting point. So if that's ever possible, I encourage them to do that, not just attorney hop or estate plan hop. You know what I mean?
Well, and it's interesting. I have clients that I have had the opportunity to work a lot with on their documents. It's interesting. I would say, though, that most people, how I try to draft documents, honestly, knowing how people are, I try to set up documents with enough generational gap.
Yep.
So if somebody dies, like it's your spouse, and then you've named your mother as your alternate personal representative because she's so good at finance.
Yeah.
And then your mom has passed, that you've got someone a generation down. And I also put provisions in my wills that if once, say, a younger child reaches a certain age, they're going to step in as the alternate.
Yeah.
So I try to help people think
ahead.
and have a document that will work ideally for 15 to 20 years.
That's great.
Based on the ages of the people in the documents, because most people don't get around to it any more frequently.
No, that's what I'm saying.
Yeah, it's just like, okay, I got that done,
Yeah.
and okay, we'll come back, which I understand. I mean, it's not like, oh, this is a delightful process. I love this. I can't wait to do it, you know.
Yeah.
Um, and so that's how I try to draft. And really also thinking in ages, you know, the people you name and appoint, like let's say you have to name a trustee of your trust for children, you know, and you name one of the grandparents, well, are they even going to be around?
To
Right.
handle that.
Yeah.
Makes no sense.
Yeah. So but you're right. Ideally, you're reviewing every 5 years.
Okay.
I do make a recommendation. I think there's some absolutes for review. I tell my clients, when your spouse dies, meet with an attorney.
To make sure, for what reason? I'll let you say for what reason. I mean,
Well,
I've seen this.
one, do you need a probate? Is
Yeah.
there tax planning?
Yeah.
What do you need to do at that point? And review the documents. And then the other time to definitely meet with an attorney is a remarriage.
Yeah.
And-
Which is very common these days. There's a lot of remarriages.
Right.
Yeah.
A remarriage, incapacity. You've got a family member, spouse becoming incapacitated, dementia, progressive illness. Now, I want to add a caveat on my practice. I don't do Medicaid planning.
Yeah.
When I say elder law, I do long-term planning. I've got trusts in my documents that handle that. But elder law is multifaceted, and one of the aspects of elder law is Medicaid planning, and that requires removing assets, and it's a 5-year look back. There are attorneys who specialize in Medicaid planning. There are a lot of very specific rules to do it correctly. And so and I'll flip it back to you, why would you do Medicaid planning? And what is the goal?
Yeah. So in my world, the Medicaid planning is some people want to preserve the assets to pass on to family members, but most of them don't work with it outside that 5-year, 60-month look back period. And so then they're in the penalty phase of the Medicaid planning, and they're doing what's called a spend down.
Yes.
Right. So they're in the spend down phase. Most of it's for housing. And I want to say a lot of people think that Medicare pays for housing. It's not Medicare. It's Medicaid that can pay for housing and healthcare, supplement healthcare insurance. And people don't understand that. And then I call it the great wealth transfer because it's so expensive anymore to be in an assisted living or adult family home.
So in your experience, because you have a lot of clients in these places, how much does memory care cost a month?
Minimum, I'm
In a
going to say,
facility?
yeah, I'm going to say minimum about $9,000 is the minimum. The largest bill I've seen is $13,000 a month. Most of my clients on average are between the $8,000 and the $10,000. That's what I write checks first of the month. As about $9,000 is the average right now. Some of those independent living, anywhere between $5,000 and $8,000, which means you get 2 or 3 meals a day. You get your own apartment, and maybe they check on you if they don't see you, but you're independent, so you can come and go. But you're in a community for retirees. It's very expensive, and so we're seeing that transfer. You sold your home, you got $400,000. That's going to last 2 or 3, maybe 4 years, depending on your income side of things.
Right. And then one last topic to mention, and I do talk about this with clients, probably not enough, but is long-term care insurance.
Yeah.
And I know I've been to presentations by people who work in that industry. I know that the cost has gone up considerably because they have actuaries figuring out how much this is going to cost.
How long they're going to live and all that stuff.
But again, that could be a really good product for people to purchase because of what we're talking about.
Yeah.
The one criticism I've heard of it is they're allowing a maximum payout now of about 3 years.
Yeah, so it's not indefinite. So you invest all this, they're large premiums, right?
Yes.
That's my experience. They're large premiums is my experience. But I tell people if you're trying to, there's different ways to do that. That's why you have to sit down and run the numbers out. If you're trying to extend something by 3 years, it might be worth it to do that. You're dealing with life expectancies and all those kind of variables that play into that, which is kind of fun. I enjoy doing that with my clients.
So you do go through long-term care.
We talk about all those things. I, at one point, was a long-term care representative when I was in my financial service
that's
business.
excellent. Well, it's really good knowledge to have. And it really, for some people, it's an incredible investment.
Yeah.
And I have a friend, they got policies and they were offered the product through her work, and it was a really good premium. And he developed brain cancer. And the long-term care policy paid for care in their home for 2 years.
Yeah.
And covered everything. And she said, if we hadn't had that policy, I would have gone bankrupt.
Yeah, she would have had to sell the house and move, and it creates a different dynamic.
So it really is a good product to explore. And again, probably another presentation, but something that I mention in estate planning, because, what assets are you going to have in your estate? And then another thing that I bring up with younger couples, because I have a background financially like you, so I can look at their asset picture and make suggestions, is I tell younger couples, max out on the term life insurance. It's cheap. Get a couple million. It's your best investment ever. And you don't need a whole life, in my opinion, at that age. There are good whole life products, but I don't think it's necessary. But you really want to know that if something happens to you, that the surviving spouse and parent is going to be fine.
They're going to be okay. Yeah, so I'm a huge believer in that too.
Yeah.
That you have those in
and
place.
So that comes up. Yeah, I've really enjoyed talking with you, Bryn.
I enjoy talking with you, Julie. Everyone thinks aging is easy. You just kick your feet up and read the newspaper and do all that, but it's a very active thing. The tax laws and just life is still happening around us, and people need to embrace that, and they need to take care of business, but they're a little reluctant to do that for the reasons.
Well, I think so people are probably looking at us, well, how old are they? Well, I'm 61. So I'm moving into that 65. They say seniordom starts with Medicare age, right?
Yeah.
So I'm looking at this, and ironically, watching it happen around me with some peers right now. It's entering into my age group. And that also is a reality check. But I think it's a way to help people and advocate for people. So when this happens, and it will, it's as seamless as possible.
Yeah. And I'm not going to say how old I am, but I am, experiencing these things. And I know the importance of it because I've been working in this space for about well over 20 years. And I've seen it evolve. And it's just preparation. I'm like a Boy Scout. Preparation is really paramount to having a successful outcome, right? And so, and again, the best gift that parents can give their kids is to be pre-planned and be prepared and be well thought out. And that takes professionals like yourself to really help that process along and get the great advice and not be afraid of it. I mean, doesn't mean you're going to get sick and die tomorrow. It just means that you're getting things taken care of. So,
yeah, and I can say a lot of people have a fundamental fear of attorneys. I would say in my area, my specialty areas, I meet exceptional people.
Yeah.
A lot of really good people who are in it for all the right reasons. And so, there's good counsel out there. There are good financial people out there.
There's good financial people. There's people who are out there willing to help you. You just have to do a little work to find them. And, but they can just save you so much time and money. It's going to cost you a little bit up front, but it's going to cost you more on the back end if they're having to manage a crisis. That's the lesson I've learned through this. So I really want to thank you for joining me today and sharing with the people out there that might be watching this. It is complicated, but hopefully we've simplified it enough that they can understand that. So if you're looking for more information about this, we have additional videos, and this video will also be posted to some of our social media, YouTube, Instagram, Facebook. And for additional information beyond that, I invite you to go to Aging Solutions website. And also we have an 800 number, 844-888-5039, that you're welcome to give us a call if you just want to reach out and maybe get an appointment scheduled to talk with someone about whether Julie can help you or we can help you at Aging Solutions. We are here to support you in your aging journey, whether that's with you or your parents. God bless and have a great day.